This is Paul Turner, immigration barrister at Imperium Chambers. Today, rather this afternoon, I'm going to be talking about the case that's just been issued by the Supreme Court, or handed down by the Supreme Court, in the case of R on the application of Miller versus the Prime Minister, and the concurrent appeal, Cherry, and others against the Attorney General for Scotland. This is a huge case. Indeed, the Supreme Court called it a one-off case. And it deals with, as you've probably seen if you've seen on Twitter or anywhere else, whether or not the Prime Minister's decision to prorogue Parliament was lawful. In short, the court held that the decision to prorogue Parliament was not lawful, and then they went on to find that because it was not lawful, they went on to consider what sort of remedy there would be, and they found that because the decision was not lawful, the prorogation, as it were, hadn't taken effect, and in effect Parliament still sat. Now, the consequences of that are, firstly, that the Prime Minister is considering, as it's put, the extraordinary ruling, though why he considered it extraordinary is quite surprising, given the comments that were made in the Supreme Court's decision, and why he thought he was going to win in the first place, given the actions and given the lack of any reasons for the prorogation. And also the consequences of that is that the Speaker of the House has indicated that Parliament will start sitting again on Wednesday, and not, as the Prime Minister hoped, sometime late in October, which was the original plan. Now, what was it the Supreme Court actually did? Well, what they did was something quite momentous and something quite unusual. As I say, they have described it as a one-off, as did Lord Reid, who gave the main speech in this particular case. Now, there were four issues that the court had to decide. Firstly, was the matter justiciable before the courts? I.e., did the courts have the power to consider whether or not prorogation and the advice given was something that the courts could get involved with, or was it something that was outside the power of the courts? And the government argued it was outside the power of the courts and the courts shouldn't really get involved with it. This the courts rejected. They rejected it on the basis that the courts have been involved in dealing with prorogation and acts of the government and the executive as far back as 1611, and cited some other cases from the late 18th century as to where the court has got involved and has found the exercise of such powers to be unlawful. So having found that the matter was justiciable, the court went on to consider the second question. And the second question was, well, if the courts can interfere, when is it lawful to prorogue Parliament? And what are the limits, as it were, to a lawful prorogation of Parliament? And the court decided that prorogation was only lawful for the purpose for which it was set out to be done. So not unduly long, and there had to be a justifiable reason for it. Indeed, the court said that the power to prorogue would be unlawful if it was to frustrate or affect the working of Parliament. And so, having come to that conclusion, the next conclusion was whether or not there were sufficient reasons to justify the prorogation. It was argued that the Prime Minister, rather's motivation was a relevant factor. The Supreme Court steered away from the motivation, not finding it necessary to go down that particular route, because the Supreme Court said that prorogation was only necessary for as long as it was required. And they heard, as they described, the unchallenged evidence from the former Prime Minister Sir John Major, who said that prorogation was usually done so that a Queen's speech could be prepared, and that in his experience that took about 4 to 6 days, as opposed to the proposed or unlawful or voided prorogation from around about the middle of September through to about the 14th of October. And after hearing the evidence and considering the minutes and the material that the government were forced to disclose, they could find no reason for such a long prorogation, prorogation is different to Parliament being on holiday or dissolving itself. It's an act where the Prime Minister advises the Queen, who constitutionally has to follow the advice, to essentially prorogue or stop the working of Parliament. Notable examples in the past have been Charles I, who prorogued Parliament, which ultimately didn't really do him any good in the end. But in this particular case, what the court considered was whether there was any reason for such a long delay. Having looked at the evidence and having considered everything, the court concluded that there was not any reason or justification for such a long prorogation, so that they made the declaration and found that prorogation was therefore unlawful. Then they turned to the issue of remedy as to what to do. They made the declaration that the prorogation was unlawful. Declaration in itself is something that will be published, something that people would have regard to. But in practical terms, what would happen? And it was advanced on behalf of Mrs. Miller and the parties that were seeking to challenge the Prime Minister, that the effect should be that the decision to prorogue Parliament was unlawful and therefore ought to be quashed or was void. And in a fairly lengthy discussion in the full decision, which is worth reading, the Supreme Court came to the conclusion that because the advice was unlawful, because the prorogation was unlawful, it had not in reality occurred, and that therefore Parliament was in effect still sitting, even though the MPs had left Parliament for the time being. But in law, the effect of the ruling of the Supreme Court is that Parliament is still sitting, and that's reflected. And then, whilst the government, I think, or the Prime Minister was intent on taking the lead as to when Parliament would sit again, the Supreme Court said that the decision would be best handled by Parliament itself, and Parliament could decide when it wished to sit again. And as I've mentioned, the Speaker, John Bercow, MP, has decided that the members of Parliament shall meet again on Wednesday, which is far sooner than the 14th of October date, I think, proposed by the Prime Minister. In short and in conclusion, it represents a humiliating defeat for the Prime Minister, who has prorogation has been found to be unlawful, whilst there is nothing to stop him in effect proroguing Parliament again, in my view, without any adequate reasons as to why the circumstances have changed. It's likely to be a very suspect decision, to put it mildly. In some respects, the Prime Minister is going to have to answer to the House and to provide an explanation, and there are already many calls for his resignation for carrying out an unlawful act, which goes to the fundamental basis of our democracy, which is that the Parliament is elected by the people, and Parliament is there, the MPs, essentially to keep an eye on or control the executive if they step out of line, which we've seen earlier in respect of the Brexit attempt that Parliament has seized control of the proceedings in Parliament and has acted and passed various laws, and has also, in respect of the withdrawal agreement, voted against the government's proposed withdrawal agreement on a number of occasions. So it is a fairly momentous decision. It clearly sets out the fact that the Supreme Court are not frightened to get engaged with this sort of decision, and it leaves the Prime Minister and his current government, which I think is a minority now, in a somewhat tricky position as to how they proceed. What they will do, what they will have to do, is give effect to the decision. They can't simply ignore it, or if they don't turn up, then it will be a strange affair on Wednesday. But in short, from my view, it's an entirely expected decision. I didn't think the Supreme Court would carry truck with the Prime Minister's view, and not only has Parliament shown that it to be very deeply sceptical about the government's handling of government, but also the courts have been exceptionally vigilant in protecting our fundamental rights, which is to have the MPs scrutinise the executive and hold them to account, something that if they're prorogued and they're not allowed to sit, they're not able to do. So it's a very important day for the United Kingdom. The Supreme Court have asserted their constitutional role and have implemented it in a remarkably fair, clear and concise decision, which I would commend to anyone who's interested in constitutional law to read, as it touches upon matters of justiciability, of the power to prorogue and the consequences of acting unlawfully. As I say, this is an entirely non-immigration related topic, but one that is highly material and worthy of comment, or at least I thought so after I finished in court today. Anyway, I hope this hasn't been too boring. Please do not hesitate to go to the Supreme Court website, where you'll see an excellent summary, and if you've got the time, please read the decision. Where we go from now and how the Prime Minister will react, whether he will resign, personally I doubt that he will, is a matter that will unfold over the next few days. As I say, it's been unusual, it's been a pleasure to speak to you, and I hope that this has been informative. This is Paul Turner, the immigration barrister at Imperium Chambers.